our list of recommendations for optimizing mining legislation. And as you know, we're focusing on Ontario as a case study, but to a large extent, I think these can be generalized. So right off the bat, we'd like to see the key provisions in the regime back in the Act. So not to be pessimistic, but to some extent, the fight was lost at the level of legislation in Ontario. Many of the things that people wanted did not make it into the Act, so that we're now fighting primarily about the regulations, and that's the pragmatic reality of it. But ideally, we would like the really important provisions to be in the legislation for reasons that most of you will be familiar with. So, in that legislation and/or in the regs, we'd like to see social impact assessment. And Joe reminded us that because of the definition of environment, this really technically is already included in environmental assessment, but it's not typically respected or effectuated, I guess. As some of the speakers have already mentioned, we'd like to see all mining activities conducted pursuant to land use planning. So land use planning first. Look at conformity with local development plans and community consent before mining activities, any mining activities take place. We'd like to see environmental assessment in the mining regime, not Class EA. Those of us that are familiar with the Crown Forest Sustainability Act know how effective/ineffective Class EA systems have been. So we want to see individual effective environmental assessment. We want an amendment to Regulation 681/94 so that that's the Environmental Bill of Rights designation of instruments that are subject to that act, so that we want to see basically all mining instruments subject to notice, comment, and appeal rights under the Environmental Bill of Rights. As a separate wish, we want anti-SLAPP legislation. As many of you know, the dispute resolution process for Aboriginal communities the details of that process are yet to be worked out in regulations. So in that process, we think that the regulation should say that Indigenous law should be given equal consideration as that process rolls out. We would like to incorporate the DRIP by reference. We'd like the legislation to also explicitly incorporate the precautionary principle as an interpretive guide. Clarification of delegation of consultation obligations to private parties. So this should be spelled out in some way. To what extent are private parties required to do the consultation, and also, even though this is already, we think, constitutionally entrenched, it should be spelled out that ultimately the Crown is on the hook for the quality of that process. FPIC, we would like all mining to be subject to the free, prior, and informed consent to affected communities. And finally, we think that there should be some kind of regulation of impact benefit agreements. But it became clear to us that most of us in the group actually don't know enough about those agreements to provide specifics. We'll be talking about that with Natasha Affolder this afternoon. So that's our wish list, and the holiday season is coming up. So we're hoping the government will oblige. Exactly, that's right.
Well, you were obviously extremely productive. Our group was much more, I guess, reflective in terms of thinking about some of the issues that were related to this idea of the roles that would be played between, of roles that could be played with respect to municipal governments, federal, provincial, and First Nations. So we talked about, first of all, the issue of consultation and how First Nations peoples here, one of the things they want is that they want to be consulted when they want to be consulted about something, and not when somebody thinks it's time to be consulted from the outside. And also on terms that respect what their means of communicating and engaging in sort of negotiations and consultations, and a right to say no. So we would reiterate the proposal that you have there to include the right to free, prior, informed consent. We then started talking about kind of principles in terms of consultation, and we heard about some of the treaty principles that exist in New Zealand that set out certain values that can then be used to define consultations, so it allows for kind of a consistency of consultations between the Canadian government and the provincial government and First Nations peoples, but then also can take into account differences between the different Aboriginal groups and different needs and different circumstances. We also talked about the power imbalance and this problem that there's probably no movement in Canada towards allowing for any sort of veto, First Nations veto. We then kind of got onto a few other issues, but I guess I want to focus a little bit on our discussion about the role that municipalities can play in terms of mining legislation, because I think this is, at this point, they don't play a role, and we heard that in other countries, in fact, municipalities have played a significant role in sometimes opposing mines in different ways, either because there's a legislative framework in place that allows them to hold a kind of plebiscite, so there can be community discussion on the proposed natural resource extraction project, which may not have necessarily legal effect, but it will have a great political effect, and it has been in some countries, including Peru. It has been determinative and allowed the community to stop a project from going ahead. We also heard about in the Philippines that there was some sort of local government code that allowed local governments to, again, oppose mining operations. So there is a role that kind of doesn't exist in Canada for municipalities to kind of get involved in the dialogue about mining activity. And if there's anything that I have completely left out, I guess there's the issue in, this has kind of arisen as an issue in Canada, where municipalities tend to, local communities, especially in remote areas, are wanting mining to happen because it will help economic development in the area. But there's no, if they were given certain powers to sort of negotiate, I guess, in terms of this, it's not clear that they would, the kind of relationship that they would develop in terms of taking First Nations concerns into account. And there's the Quebec case of, is it Malartic? Mm-hmm. Where there's a huge gold mine going in the center of a town. And in terms of the consultation, we heard that it was hand-picked and that dissenters were sidelines, and that the Algonquin First Nation in the region that was very close to the municipality wasn't even consulted, and yet we heard also that from the government's point of view, it's being put forward as a successful story that the company really consulted well with the community. So there's this kind of problem because we don't have a legislative framework for setting with principles to engage municipalities in this discussion as to what would happen if municipalities did become more involved in a mining policy debate. Is there anything else that anybody wants to add? Okay. So it was more of an issues as opposed to recommendations.
Wow, well that was an excellent morning. We're 5 minutes ahead of schedule, so very successful. Lunch. Lunch should be arriving momentarily.
In 5 minutes.
In 5 minutes.
Linda,
yes.
I might suggest that we try and start our next session slightly earlier if Natasha arrives, so that, because there are 5 people speaking.
That would be great.
Only an hour session, so if we can aim to start at 1:15, then, and we'll see if our panelist arrives in time. If we want to start without her, obviously, that would be very nice. Then we'll do that so that we can allow enough time, because even with 3 people, we've been going almost to the end, so I think that'll be helpful.
Sure. All right, so let's try to get back here for 1:15. Thanks
Great.
very much.
And thank you very much so far for the most stimulating presentations and discussions. I am awestruck by the expertise in this room. It's just incredible. So I really appreciate you all engaging.
All right.
All right.
Thanks. When I saw the program, I knew what I was meant to be speaking about, our human rights adequately protected in domestic mining operations. And then when I saw that I was speaking at 1 o'clock on the program, I knew my talk had to change, because with this group, I was pretty sure that the question, are human rights adequately protected in the mining industry in Canada, would be answered well before 1 o'clock, if not well before the start of the entire conference. So I saw inherent in the question posed by Penelope and Linda a challenge. And for me, that challenge was to answer the question, If we know that human rights are not being adequately protected in the Canadian mining sector, what are we going to do about that? And so given 10 minutes, that's what I want to talk about. And I want to address very specifically one legal tool we have for addressing the way human rights are dealt with in the Canadian mining operations, and that's to look at the instrument of environmental contracts. I'm sure this morning contracts of various forms were discussed, whether impact benefit agreements or other forms of agreements between First Nations and governments, or First Nations and mining companies. And I know that we're going to have the privilege of hearing in the next panel a talk about concession agreements, petroleum agreements, and a whole range of contractual instruments that can be used as tools to protect the environment and to increase Aboriginal participation. So in the few minutes I have today, I thought it would be a good use of time for us to focus on the contractual instrument and see what promise contracts hold and what assumptions we have about contracts and their relationship with regulation that needs debunking. My own research right now looks at environmental contracts as an instrument of environmental protection in mining agreements, particularly in the Canadian North, but also across the world, and looks at the transfer and the different forms that these agreements are taking. And I realize we have Brad Morris in the room, who I believe was instrumental in working around the Acadie Agreement and some of the diamond mine projects that have really been pioneers in leading to environmental contract use in Canada. So hopefully we'll have a rich discussion drawing on expertise far beyond my own. I want to tell you first, for those of you who don't spend your days and nights reading this academic literature on contracts, that there's a real sort of excitement or renaissance happening in the scholarly literature around the idea of contracting. And we have, particularly emerging out of the EU, to some extent out of the United States, and also from Japan, a sort of positioning of contracts as the new solution to the inadequacies of regulation. And I want to give you a bit of a flavor of this literature. Are you searching for innovations in environmental policy? Flexibility. Are you worried about the calcified nature of regulation? Shocked by gaps in legislative regimes? Are you troubled by the dispersed lack of coordination between environmental policy tools? Are you unable to trust government?
Yes, I am.
Are you searching for more localized, more context-based forms of regulation? If so, look no further than the contractarian paradigm of environmental governance. At least advocates would suggest. The very literature we now have around environmental contracting tends to posit it in a very new governance sort of way in opposition to regulation. So on one side we have environmental contracts which are innovative, cooperative, private, negotiated, effective, paradigm shifting, customized, new, creative, and the stuff of lawyers. On the other side, we have regulatory approaches. Traditional, confrontational, imposed, public law, ineffective, business as usual, ill-fitting, calcified, of limited creativity, and a field we share with political scientists. So, in other words, if the literature is to be believed, there is one solution. And I can tell you, after spending a summer in the Northwest Territories learning about the record of these agreements, we now have about a decade of experience of environmental contracting in the Canadian North. The dichotomy is less sharp. And I think, if anything, we need to fight the knee-jerk reaction to separate contracts from regulatory approaches and realize that the only way contracts work is when there's a supportive regulatory regime. And so, in other words, rather than treating these instruments as oppositional, we need to find the best puzzle way of really putting these pieces together. And I think this is something that we're attempting to learn from the experience, at least we have so far in this country, with environmental contracts. The project I'm going to talk about a little bit is the Acadie Diamond Mine in the Northwest Territories, because this was one of the first projects in the Canadian North where we saw an environmental agreement emerge. So I think we can learn from the experience of why an agreement happened here and not elsewhere. It's also the agreement that has really served as a precedent for other diamond mine projects in the North, and continues to be, I think, the template that is at least consulted by INAC in looking at further developments in the North and whether they'll have contracts as an element or not. If we look at that project specifically, we see that it attempted to do two things which really are key concerns of, I think, this group today. The first is address environmental monitoring, and the second is address Aboriginal participation. And the way this agreement came to being is quite unusual, because there was no legal basis, and indeed for the company, no warning that such an instrument would be demanded. Speaking to the company's lawyers was quite an interesting experience, not only because the lawyer quickly put me on the sidecar of his motorbike and said, I'm going to take you around and show you where this happened. And I had chosen to wear dress that day, which I've learned not to do in interview situations. But it was interesting in that the first response of the lawyers to being told that an environmental agreement would be required was, this is completely illegal. Let's go to court. You know, we can have an application here for judicial review because we've been told we need these 36 permits. We've done everything to get those 36 permits, and now we're having another pile added, including impact benefit agreements and environmental agreements, and finally, a socioeconomic agreement with the government of the Northwest Territories. So an agreement was indeed concluded because the company's pragmatic approach was whatever was going to get stuck in the environmental agreement would be imposed on the company in one way or another. What was unusual was that the company was told that the agreement would be between the government of Canada and the company and the government of Northwest Territories. But at the very first meeting to negotiate the agreement, the Aboriginal parties insisted that they have a place at the table. And at the second meeting, the table was reconfigured. The Aboriginal groups and the lawyers for the company sat in the middle, and the government had moved to the side. So that we saw a real factual presence and a reflection of Aboriginal issues in the negotiation of the agreement. But we saw by the end, when it was time to sign the agreement, that the Aboriginal groups were not parties. They instead signed an implementation protocol, which meant that the agreement couldn't be changed without their signature. But it was a major sort of distinction between the parties that actually shaped the agreement and the parties that were signatories. And I think this highlights one of the limitations of environmental contracts, and that is the issue of privity of contract. Only those parties who are parties can affect what happens after the agreement is signed. And so we see a major problem with the environmental monitoring boards in the Northwest Territories, in that they were created to give effect to the agreements, but they're not parties. So that when their budget is not being paid by the company, when their work plans are not being approved, they can't do anything, even if that violates the agreement itself. They have to ask one of the parties, the government of Northwest Territories, the government of Canada, or the company, to do something about it. And that's not something that's going to happen in a dispute resolution system where each party's going to pay the cost of dispute resolution. I think another limitation of contracts is the fact that we don't have automatically a voice in the public interest. These are closed negotiations in a room like this with the door shut. And there aren't other interveners, there aren't amicus curiae briefs, there aren't other mechanisms for having the voices of those other than the parties heard. And this is why you don't wear a mic when you do presentations, because then your voice isn't heard. But finally, I think, given in the last minute, I want to suggest that these agreements do hold some promise, that it's not just limitations, though the limitations need to be realized. And I think the promise lies in the fact that these are context-specific arrangements. They provide an ability to address the specific concerns of the parties in that specific situation. So they empower local populations in a way that legislation and regulation in a sort of broad brush way can't. I think they're also able to be renegotiated like any contract to continuously respond to the new conditions of projects. And I think that going into a major project, communities certainly don't know what to expect. And contracts are a sort of deft enough tool that they can be renegotiated to address specific concerns. And finally, I think why I think contracts hold promise is that I've become increasingly pragmatic. And I think the things I'd like to see in legislation, and I'd like to suggest that legislation or regulatory approaches are ideal in some circumstances, well, over time you realize it's not going to happen. And I don't think we want to give up on making broad brush sweeping revolutionary change through legislation. But to the extent that we need to take on some of these issues with bite-sized chunks, I think contracts offer such a bite-sized chunk and such an incremental way to sort of ratchet up towards where we're trying to all head. Thank you.
Right, so I'm going to, the title is very broad, but I'm going to actually narrow down and focus on one very specific issue that Mining Watch Canada has been quite concerned about and doing some work on over the last little while. And so that'll sort of give a bit of a focus to the presentation. Which one is it? This one? Yeah. And unfortunately, I've got to go through a bit of background for this, so I'm just going to try and do that as quickly as possible. So you're all familiar with the Fisheries Act. It's the oldest piece of legislation in Canada, 1868. There's a section 36.3 or subsection 3 in the Fisheries Act, which essentially is a prohibition against dumping what they call deleterious substances into waters frequented by fish, which is very broad, very general. The mining industry started lobbying in the 70s and wanted a definition of deleterious that would be more narrowly defined than just a broad prohibition against all deleterious substances. In 1977, the metal mining liquid effluent regulations were promulgated under Section 36 and defined deleterious very, very narrowly. But the part I want to focus on is that total suspended matter was restricted to 25 milligrams per liter on average per month. And what that essentially does is it says you cannot put tailings or waste rock into waters frequented by fish. So that was pretty good. In 1992, there was general agreement, including among civil society groups, that there needed to be a reevaluation of the metal mining effluent regulations, liquid effluent regulations, because they dated to 1977. And a lot of the concerns from civil society groups were that the metal levels of the very restricted number of metals that were actually being looked at were way too high. That other jurisdictions around the world had recognized that much lower levels had a toxicity that was significant, and so those levels needed to come down. Civil society also wanted to add metals, so I won't go into all the sort of details of it, but it was a very, very long consultation process with lots of studies done. And in 2002, the new metal mining effluent regulations came into law. The point again that I'm going to point you to is total suspended metal material, because that was actually lowered, which was one of the very few things that went in the right direction, to 15 milligrams per liter per month. So if you just look at that, you'd say, okay, the prohibition against dumping tailings or waste rock into waters frequented by fish is still in place. I won't go through what stayed the same. The worst thing that stayed the same, of course, that all the metal levels stayed at 1977 levels. They're still at 1977 levels. The biggest surprise when the regulations went to Gazette 1, Canada Gazette 1, was that after 6 or 7 years of intense negotiation, consultation on these regulations, this entire schedule had been added that never had been discussed. There had been no discussion about the schedule. The schedule is called Schedule 2. And in a nutshell, what Schedule 2 does is it redefines anything that is placed on Schedule 2 as a tailings impoundment area. So if you were a lake, if you were a river, if you were a wetland, and you get put on Schedule 2, you are no longer a lake, a river, a wetland, you are now a tailings impoundment area. So even though you may have Atlantic salmon and brook trout and God knows what other kind of fish and other sort of biota and flora associated with that ecosystem is now defined as a tailings impoundment area, and so it can now be used as a dumping ground for industrial waste. So when the schedule first appeared, this is what it looked like, and it already had 5 lakes on there. And they were all historic mines. They were all existing or historic mines. And of course we protested this as soon as we saw it, and we were essentially told, but in a very sort of sly way, that this was something the lawyers had cooked up. This is something lawyers had cooked up because if the regulations had come into effect in 2002 without this schedule, then there would have been these existing mines that would have been out of compliance. We did ask whether there was any chance that this schedule could possibly be used in the future to destroy uncontaminated, healthy water bodies. And to the credit of the official that we actually ended up talking to, he didn't outright lie. What he said was, and we were 2 women, so he said, ladies. He said, well, potentially, hypothetically, of course, that's maybe possible, as though he hadn't really thought about it before that moment. But, be realistic. It took 25 years for these regulations to be amended the first time. It took a 6 or 7 year process. It's got to go through Governor and Council approval. It's got to go through Gazette 1, Gazette 2. It's a regulatory amendment. It's not a small thing. So mining companies are not going to wait around for the regs to be amended every time they want to use a lake or a river. So basically, that's not going to happen. Well, 2 years later, we were told the regs were going to be amended again. They came out in 2002, 2004. We were told they were going to be amended again, and we were told in the spring of 2005 that there were going to be 2 brand new healthy lakes put on Schedule 2. These were 2 lakes in Newfoundland that did in fact contain Atlantic salmon and brook trout and had otter and other species associated with them. So we fought this tooth and nail, lost in 2006, and the first 2 healthy lakes were put on Schedule 2. And they are now currently being destroyed by mine tailings. And this is one of those lakes. This is Trout Pond, it was actually called. They call everything a pond in Newfoundland, but it's a big pond. And it's been downhill from there. In 2008, well, in the course of 2006, we asked Environment Canada, so these 2 lakes in Newfoundland, is that sort of going to be it? Oh, no. We were told informally there were 20 other projects going to be going ahead throughout the country that were looking at using natural water bodies. So essentially every new mine that was near a lake or a river or a wetland was looking at using that water body. We asked for a list. We didn't get the list till late in 2007. It was a huge kerfuffle. We got a much reduced list, and we were specifically told we weren't going to be given any of the names of the projects that weren't in the near-term pipeline. But this was a list we were given. So you can see Nunavut, Newfoundland, British Columbia, Manitoba, Northwest Territories, just all over the country. And we were also told in 2008 that they were going to chase, I've got 2 minutes left. 3 minutes left. Okay, they were going to chase 8 of these projects through. Anyway, I'm going to go quickly. This is one of the lakes that is now being contested in British Columbia. It's called Fish Lake. This is actually going to be drained, and I know, Trout Pond, Fish Lake. And the other one that's already being destroyed, or going to be destroyed now in Nunavut, that's gone onto Schedule 2 is called Tail Pond. So what's in a name? This one is actually going to be drained, and they're just going to put their waste rock here. This is Little Fish Lake, which is actually also quite large, and this is going to become the tailings impoundment in this case. So now there's two lakes being destroyed. Yes, and so we've asked for further lists to know what else is coming down the pike, and they're not going to give them to us anymore. And what I essentially wanted to tell you was that, opposition is certainly mounting around this. In particular, there's another pond in Newfoundland called Sandy Pond. It's a non-native community. I don't have time to read these quotes to you, but these came out of the Globe and Mail article. And basically, this person's saying we're going to chain ourselves to trees and we're going to stop this thing. But it's looking unlikely. It looks like that pond's going to be toast as well. In British Columbia is where the struggle is right now. Both of these 2 projects that people are on First Nations land. These First Nations are adamant that they will not allow their water bodies to be destroyed by mine tailings. So again, I won't read you the quotes, but this is where the struggle is now. And that brings me then to my final piece, is regulatory policy and implementation concerns, and I'm going to have to go really fast. 2 minutes, okay. There's a whole suite of problems, regulatory policy and implementation problems associated with this. And I've done a couple of petitions to the Auditor General, and you can see what I'm going to say now in very fast flight in more detail there. But there's essentially a failure to consult. There are a number of government regulations and policies that talk about how consultation around amending regulations needs to be done, both for Aboriginal people and then very specifically for Aboriginal people and also broadly for the public at large. Again, I was going to read you some of these quotes, but I won't, just to simply say that this did not happen in the case of Schedule 2. So all of these sort of Privy Council and other cabinet directives and Government of Canada policies on how consultation for a regulatory amendment should happen clearly were not followed, including for Aboriginal people, because there were no Aboriginal people who were told about this Schedule 2 coming along, although a lot of the lakes are on their land. There's also a lot of issues around the regulatory impact assessment statement. I mean, there's a problem, a broader problem called, I would call the failure to provide adequate information for decision making. Every time one of these water bodies comes up for destruction, there's never a cost-benefit analysis done. There is no assessment done of the natural capital values of that ecosystem and the loss of that ecosystem. So the ecosystem is essentially evaluated at zero. It has no intrinsic value or natural capital value or use value, etc., which we all know, these ecosystems have. And so then when they start looking at alternatives, it very quickly turns into the water body being the best place to put the mine tailings. And this becomes a problem then when you get into the actual amended regulations, because as part of amended regulations, you have a regulatory impact assessment statement, which is supposed to show you the costs and benefits of any change that is made to a regulation. Well, if you're not evaluating the cost of the loss of an ecosystem, you're not providing the public with a cost-benefit analysis of any sort. And what's even more remarkable, the first RIAs that came out in 2001, when the new regulations were gazetted with the Schedule 2 on them, didn't even, the whole regulatory impact assessment statement did not even mention Schedule 2. It just didn't even do an assessment of what the impact of that schedule could be on Canada broadly. And obviously there's other questions to be raised around sustainable development strategies. Environment Canada has a bunch of sustainable development strategies, and how does this fit with that? You know, I really kind of rushed through this. The other thing I wanted to briefly say something about was rights. As we're starting to look at human rights in respect to these sorts of issues more and more, I think there's quite a question out there, at least in people I talk to, about how do you do that? How do you integrate looking at human rights with these very specific Canadian situations? And part of this that I've also sort of skipped over is the whole problem with environmental assessment at the moment and consultation within environmental assessment. And what I would say is that, you know, we're starting to get some guidance for how to do this through the human rights impact assessment processes that are out there. And there's one interesting document that was done recently, which was an assessment of the IFC, International Finance Corporation's performance standards from the perspective of human rights, and using something called the Danish model, which is a human rights compliance assessment tool. So it looks at mostly, I think it's all mining companies, and says, okay, how does this mining project, how is it compliant with international human rights instruments? And it breaks down those instruments, and then it looks at the projects, and it looks at how they're compliant or not. And without sort of going through Schedule 2 and doing this, although I've sort of started to do that, obviously there's a lot of areas in which it's very non-compliant with Schedule 2, and particularly where First Nations are essentially saying over our dead bodies, this is not going to happen, and they have no right to say no, and the consultations are shoddy. So I think I'll just leave it at that and recommend this document for reading, for guidance on how to integrate human rights thinking into these assessments.
I'm used to standing. I never make submissions to a judge sitting, so if you'll bear with me. I'm going to talk about something somewhat different from what you folks have been chatting about over the last half a day or so. Basically, the situation when there is nobody around at all to deal with in relation to this kind of problem. There has been for about, what year is this, 2009? 8 years, a program underway, which actually Nadeem mentioned this morning, the National Orphaned Abandoned Mine Initiative. That's what NOAMI stands for. It also stands for No Friend. And indeed, these are sites that have no friends or no responsible persons. There are a number of problems with these sites, and we're going to talk about the problems, and then we're going to talk about the law in relation to those problems. What I was asked to do for No Friend beginning in 2002 was actually look at the question of orphaned abandoned mines from 3 different perspectives. I've actually written 3 different reports for them. I've brought 2 of them with me. One was published in the CELRs in 2006. All 3 of them, this is actually the largest of the 3, and this one is predominantly what the subject matter of this talk is about. Looking at these 3 issues that are set out in this second slide. And so this is the roadmap to what I'm going to talk about. Recognizing that I have 9.5 minutes or so. And I'm going to start with the background. There is no single definition, mainly because no piece of legislation actually recognizes the notion or the concept of abandoned mines. MAC is the Mining Association of Canada, and that's their definition. AGBC is the Auditor General of British Columbia, and that's their definition. Essentially the same. You've effectively got a situation where there is no responsible party, or that party has, for whatever reasons, left the jurisdiction, and the site has reverted to the Crown, and the question is, there's a serious problem at the site. Who's going to pay for the cleanup? Why do we care about orphaned and abandoned mines? That's what slide 7 is about in terms of identifying some of the problems with these kinds of sites. And actually, the picture gets worse. There are, of course, both international and domestic examples. These are some of the international examples. I think probably the most important thing to recognize is that with some of these sites, we are talking about grievously serious contamination. There are at least 50 sites in the United States that are Superfund sites. And these are not tiny mines. These are huge, huge abandoned facilities. The situation in South Africa and United Kingdom and elsewhere is bad as well, although not as nearly well documented as it is in the United States. Being in Canada, we of course have our own examples. CESD is the Commissioner for Environment and Sustainable Development. AGBC is again the Auditor General for BC. When I talk about hundreds of thousands of tons of highly toxic chemicals at these sites, just to give you one example, the giant mine has 237,000 tons of arsenic trioxide. The estimated cleanup costs for that one site alone, $30 to $400 million. So when the CSD did its review of the situation several years ago, their estimate of at least $500 million to clean up all orphaned and abandoned mine sites just in northern Canada was deemed or characterized by that office itself as conservative. I think it's off by orders of magnitude. Come back to some examples. Why do we care was the earlier slide. This is the scope of why we should care. It's enormous. The situation in Ontario is kind of interesting. When I was actually doing the last of the 3 studies, I was advised by the Ontario government that there were 5,600 abandoned mines in Ontario that would require roughly $500 million to clean up. I just checked their website in preparation for this workshop, and the estimate of the number of orphaned and abandoned mines in Ontario has jumped to 6,000. Although ironically enough, the estimate for the cleanup costs with respect to those mines has stayed at $500 million. I ask you to go figure how they're doing their math. What are some of the issues? UNEP believes that the primary issues are financial and legal. I think that has to be, I think you also have to recognize that depending upon your rehabilitation goal, i.e. and the technology that's available, you've got to factor that in as well into what the financial cost would be. The sort of policy question is who's going to pay, and up to now, with some exceptions, the folks who have mostly paid has been the Canadian taxpayer and the victims who live near these sites. For the study that I did for Noemi, this is what I looked at: 50 statutes, 80 regulations, 30, I would say, non-regulatory programs across the country. And how we sliced the review was set out on slide 14 in terms of examining each statute. I can tell you that when we got down to about bullet 8, we were not finding anything in the law. And that's really the burden of my comments to you this afternoon. This is an area, this is a problem for which our law has absolutely made no acknowledgement or recognition, which is the burden of the next slide. Our law is silent on this problem, and it assumes, it always assumes, the existence of a responsible person that you can impose some obligations on. By definition, orphaned and abandoned mines ain't got no responsible person. And so what happens in at the end of the day is that governments are left using emergency powers under these statutes and cobbling together public funds where they can to remedy the problem. And often, of course, they are well behind the curve in terms of the amount of money they need given the scope of the problem. I would say that probably our mining and environmental laws are most effective, and that's relative to this situation of orphan abandoned mines, when they're dealing with operating mines, when they're dealing with closed or closing mines, where there still is somebody out there who's responsible and has a pocket, deep or otherwise. But that, by definition, is not the situation, thank you, with orphan abandoned mines. As I said earlier, they revert to the Crown, they become a taxpayer responsibility. So that's why the situation is as bad as it is when it comes to this category of activity. And I think I mentioned already that the estimates, I think, are grossly under what they should be in terms of the total likely bill for dealing with these sites. The next area that we looked at in the so the issue of liability is clearly not dealt with in our law. The issue of funding is not dealt with in our law very effectively, again, because it's crafted to deal with the front end of the process. When I say funding, I mean financial security requirements, which we may have talked about briefly this morning. They're not effective at all under this regime for reasons that become fairly obvious. It's very difficult to predict in advance how much it's going to cost to clean up a mine if the operator goes south, sometimes literally. To give you a couple of examples, the amount of security that was available for the Faro mine north of 60 was $14 million. The estimated cleanup cost was $200 million. Situation for Mount Nansen was about $450,000 was available from the security. The estimated cost of cleanup was in excess of $6.5 million. So we haven't been very good at predicting in advance what the amount of security will be that's necessary to ensure that these sites are cleaned up if, for whatever reason, the operator disappears. Which is why, in my view, financial security requirements cannot be the only financial approach to dealing with this problem. And why is cost recovery, which is also an authority I found in virtually every statute I looked at, ineffective in this context? It's ineffective for the 5 reasons that are set out in the first bullet. If there's nobody around, there's not going to be cost recovery. So what we focused on at the end of the day was how do you supplement financial security in a situation where there might not be enough money as a result of the security and the responsible person has skipped or disappeared. The answer is a fund imposed on industry directly at the outset as a second obligation in the form of fees. 1 minute? Okay. And I'll come back to that in a second. The last approach that has been tried and is used in Canada is a collaborative approach involving companies that actually literally will choose to rehabilitate a site, usually because they think the site has some financial value in it. I found far too few examples of this working. Well, I shouldn't say working. I found simply far too few examples of this occurring. Certainly you wouldn't want to use it as the only way, because when you've got anywhere from 6,000 to 10,000 sites, this kind of approach is not systemic enough to work. There are 4 kinds of collaboration. The first 2 are have an advantage if you've got 2 levels of government paying for it, but the problem is so large, even that's not necessarily enough money, and it happens too slowly. The second 2, which involve the private sector, is better. The only problem is those kinds of collaborations have been used fairly infrequently. And one of the problems is if you get a financial commitment from the industry that's a fixed commitment, like the one of the Britannia mine, $30 million committed by the industry. The initial assessment of public monies necessary was $45 million, but that number has continued to grow, and the agreement fixes or caps the industry's contribution at $30 million. So what began as a reasonably decent arrangement between the parties is increasingly becoming a burden on the taxpayer. What did I recommend? I couldn't stop making recommendations in this area. I made about 10 pages of recommendations. The central theme of the recommendations is that, A, we need a financial engine to comprehensively deal with this problem, and secondly, you need to put that financial engine in a legislative framework and to address it on a systematic basis. And these are the sites for where you can see the 3 reports.
Great, thank you very
Okay.
much. All right, I'm going to time myself, but I'm quite concerned about reprisals from the group if I go over. So I'm going to try to be brief, but if I'm not, do let me know. As Penelope said this morning, in measuring Canadian performance against our international human rights obligations, we've defined international human rights quite broadly, and I'm going to be speaking specifically about the category of environmental human rights. So I want to talk about how we can apply environmental human rights to the problem of mining, and much of this is translatable to other natural resource contexts. So if we look at the literature, there are actually 3 different kind of outputs from the application of human rights concepts to environmental problems. First of all, we see courts and scholars recognizing environmental deprivations of existing rights. And this is really just an ecologically literate reading of existing rights. So, if we understand that human beings are not in any way separate from the natural environment and that we need environmental integrity in order to live, then we can understand that a state, killing someone by a poison incinerator is really no different legally from a state killing someone by extrajudicial execution, for example. And this is quite well accepted at the international level. At the opposite end of the spectrum, we have an emerging, perhaps emerged, norm of customary international law known as the right to environment. This is an independent, freestanding right, and the contours of the right are a little bit vague. I and others have argued that if this right adds something beyond other existing rights, it must have some kind of unique content. And Dinah Shelton and others have argued that that unique content might include, for example, intergenerational protection and the protection of aesthetic values. In the middle, we have a category which Shelton called environmental rights and I call procedural environmental rights, because they are procedural environmental rights that really involve the right of access to information, public participation in environmental decision-making, and access to justice for environmental wrongs. So I'm just going to briefly talk about how each of these categories may apply domestically, both theoretically and more to the point in terms of advocacy. So with respect to the first category, recognizing environmental deprivations of existing human rights, I really think this is an area we need to push as scholars and advocates. Recently published a piece called An Ecologically Literate Reading of the Canadian Charter of Rights and Freedoms. And I really argued there that Canadian courts, and particularly appellate courts, we know that these kinds of arguments don't do that well at the trial level. But when we end up at the Supreme Court of Canada, I think we should be encouraging them to look to the international jurisprudence on environmental deprivations of recognized rights. This is well established at the international level, and there's no excuse to not be doing this here. Specifically, obviously, Section 7 guarantees of security of the person are implicated in a lot of the stuff that we're talking about. And this morning, when we discussed the potential of Section 7 and the challenges, Professor Maeder raised this challenge of finding a principle of fundamental justice that has been violated. I would suggest that anytime you have a health-affecting environmental issue that is clearly disproportionately affecting a marginalized group, you have a violation of principles of fundamental justice. So if we can show environmental racism, in other words, we have a violation of principles of fundamental justice. If we can show that, 80% of toxic mine tailings are located in Aboriginal communities, I don't see how that can be in accordance with the P's of FJ. So, so much for the first category. The right to environment. I'm not super hopeful about the justiciability of that right in Canadian courts, but the Supreme Court of Canada has recognized it on a couple of occasions. And, my experience with principles of customary international law is that if you can convince the court that it needs to get to the result that you want, and you can provide a viable, plausible domestic law avenue, then the customary international norm may be mentioned, which helps you in your articles and in future litigation, and it's sort of a buttress. It's not going to get you there as a primary vehicle, but it's certainly something to keep in mind. Procedural environmental rights in Canada, actually, we have done quite well relative to other countries in the world in general, but the mining regime has been weak compared to other natural resource sectors. So, the blanket exemption from environmental assessment, the fact that most mining instruments are not designated under the Environmental Bill of Rights, this is an area where we really can improve, because in fact, the mining regime is not meeting the basic standards that we see in other Canadian sectors in terms of procedural environmental rights. All right, that's all I'm going to say.
Now I know the stress of the 10 minutes.
Right, I'm sitting right next to you.
I know, breathing down my neck.
I got your number.
So, I'm going to talk about another key participation right that underpins the other participatory rights that we've talked about today, the rights that Linda just talked about, and the Indigenous right of free, prior, informed consent, and even the right to consultation. That is the right of peaceful protest. And peaceful protest, the Canadian courts have noted the importance of this right because it allows those who don't have power, who don't have access to the media, who don't have money to voice their concerns, to get some public airing of these concerns, and to be granted relief, and which can, in the end, benefit society at large. Manfred Novak, who's an international human rights lawyer, has noted that because of the democratic function of peaceful protest, that states have a stronger obligation to protect this right than they do with respect to other civil rights that are directed towards private interests. And I want to look at the right of peaceful protest in the context of two of the cases that we've mentioned today, the Frontenac and Ardoch case, and the Platnex and the KI First Nation cases. And just see, both of these cases concerned peaceful protest in the form of a blockade by the First Nation in question, against mining activity on lands that were subject to Aboriginal rights and title claims. The companies had legal rights under the pre-2009 Ontario Mining Act to conduct mining activity on these lands. There had been consultations during the course of these cases between the province, the First Nation, and the company, and these consultations had been deemed to have failed to resolve the dispute. And in the end, injunctions were issued in both cases against the First Nations peoples to end the protests. And the protests did not end, so there were contempt orders that were made and harsh sentences were imposed on these First Nations people. 6 months incarceration in both cases, and in the case of the Frontenac case, there were also fines of between $10,000 and $25,000 were imposed. And the end of it was that the companies were permitted to begin their exploration activities. So the international law on the right of peaceful protest can be summarized as follows, and this is very brief, but it's protected if it's peaceful, and it includes civil disobedience. So blockades where no force is used and where there's no active resistance can be is protected. And only those who are committing criminal offenses during the protest should be arrested. The right of peaceful protest can obviously be restricted, but it has to be done according to an international law test. It has to be in conformity with the law, and the restrictions that are imposed on protest have to be necessary and proportionate to the aim that they're seeking to follow. So, and there are only certain aims under international law, one of which is the protection of rights and freedoms of others. Others are national security, public safety, public order, but for our purposes, we're looking at the protection of rights and freedoms of others. Now, the restrictive measure can't undermine the rights, so an injunction and a contempt order should be a measure of last resort after less restrictive measures are tried. Now, Novak also notes that these measures should correspond to a minimum democratic standard, so a criteria of pluralism, tolerance, and broad-mindedness, and be accompanied by the principle of popular participation in political decision-making. Now, when you're limiting and doing this balance between the right of peaceful protest and the rights of others, the jurisprudence of the European Court of Human Rights suggests that when the rights of others are not equal human rights in the sense that they're protected under the Convention, then only indisputable imperatives can justify the interference with the enjoyment of the right of peaceful protest if it's not a Convention right. And the right to property is actually not protected under the International Covenant on Civil and Political Rights, to which Canada is subject to an obligation. Peaceful protest can be limited by private property rights. Obviously, if you want to have a protest on somebody's land, you have to ask their permission, but I want to discuss that later. Now, in terms of protest in the domestic mining sector, obviously the biggest issue, and this was mentioned by Graham this morning, is where injunctions are sought to quell the protest. And in contrast to how the courts have dealt with public protests that actually takes place on purely public government property, for example, where the protest takes place on private property or on public lands that have been lawfully closed to the public, or it interferes with economic activity, and this has been pointed out in an excellent article by Heather McLeod-Kilmurray, the courts have tended to favor the protection of private property rights over human rights and other public interest concerns. Now, the right to peaceful assembly does not appear to have been argued, 3 minutes, no problem. Does not appear to have been argued in either of the two cases, the Platinex or the Frontenac case, but because of the way the injunctions were granted to put an end to the blockades and the contempt orders and the harsh sentences, it raises serious concerns about whether the common law, in terms of how it deals with these types of issues, will effectively protect the right to peaceful protest, and whether the courts can, in the test for an injunction, actually do the proper balancing to ensure that peaceful protest. So there's a test for injunctive relief, a three-part test. A serious question has to be shown it has to be a serious question to be tried. The applicant has to show irreparable harm. There has to be then a balancing at the balance of convenience stage that favors the applicant of the injunctive relief. And my argument is that this is not amenable to assessing whether this injunction, which is going to restrict protest, will actually satisfy the three-part international law test. Now, usually, it's been said in the courts that at the balance of convenience stage, that's when you're going to decide if the case in terms of where charter issues are raised, so the right to peaceful protest, for example. But in natural resource cases, it's really important as to what constitutes irreparable harm. So that's also crucial because it'll affect how the rights are weighed and how the harm is weighed at the balance of convenience stage. Now, in both of the cases, in the Frontenac and the Platinex case, putting the company out of business was the irreparable harm to the company, and that was weighed against exploration activities that were deemed not to have much of an impact because they were only a certain number of drill holes that were 2 inches in diameter, so the minimum environmental impact, and they probably wouldn't affect the trapping lines, and we'd make sure that they wouldn't have effect on Aboriginal rights. But of course, that kind of weighing doesn't really take into account the Aboriginal perspective and the fact that this exploration activity will probably lead to mining on the land. And also at an earlier stage in the Platinex case, I need to take a breath. The judge had actually taken judicial notice, had noted that exploration activity would cause irreparable harm to the KI Nation. And I quote, not only because it may lose a valuable tract of land in the resolution of its claim, but also, and more importantly, because it may lose land that is important from a cultural and spiritual perspective, and no award of damages could possibly compensate for this loss. So what I argue then is that the balance of convenience stage does not clearly provide for a determination, a weighing of this three-part test. Now, under international human rights law, you can restrict protest to protect private property, but in these two cases, the property in question was not purely private. They were rights of entry and mining leases that were mainly on Crown land, and it was land that was and remains subject to Aboriginal rights and title claims. And so the nature of the property falls into a category that is not purely private and in fact has a significant public component. Now, the injunction and contempt orders should have been measures of last resort, but in both cases they ended the protest, and once consultation was deemed to have failed. And it wasn't really clear that this was the only way that the courts could have gone. And so under international human rights law, I would argue that that could constitute a forceful, illegal breaking up of the protest. Civil disobedience, as I said, is protected under international law, and people should only be arrested if they're committing a criminal offense. And even if the arrest is lawful, under international human rights law, if these blockades are protected, then, and they're arrested, then that would constitute a violation of the right not to be arbitrarily detained. One last point is that the sentences that were given to the contemptors would not satisfy the proportionality test under international human rights law. They were even, the Court of Appeal found they were disproportionate. They were considerably more severe than the sentences imposed on other protest blockade cases, not against Aboriginals, where nominal fines and short terms imprisonment were imposed. So it remains to be seen whether the Ontario Mining Act that requires consultation and provides a dispute settlement process will effectively deal with issues raised by this conflict between private rights and Aboriginal rights. But the Mining Act does not provide a right of or process through which Aboriginal groups can prevent mining activities on traditional lands. And also, it doesn't ban uranium mining, which is one of the things that they were protesting against in the Frontenac case. So these protests are likely to continue. Thank you.